Originally, the Jamaica Observer reports that Justice Minister Delroy Chuck on Tuesday charged that some judges are requiring children to plead guilty before referring them to the Child Diversion Program, raising concerns that minors may be acquiring criminal records through a process that was specifically designed to rehabilitate them without formal conviction. Chuck, the Justice Minister, raised the issue as the Joint Select Committee reviewing the Child Diversion Act heard submissions from the Ministry of Justice, which warned that confusion in the law is distorting the program's original purpose to steer children away from the formal criminal justice system. Chuck, who was also chair of the committee, said the court's current practice in some cases run counter to the intent of diversion, which is meant to intervene before a child enters the conviction stage. The court literally, in some cases, not in all, but literally asks the child, "Did you do it? And if you did it, then you plead guilty." Now, that is not the way it should be, because the idea is not to plead guilty and then you say you go for child diversion, Chuck told the committee. He stressed that the program of diversion is to allow children to avoid criminal records altogether if they successfully complete the program. The question is this an appropriate case for child diversion? And if it is, the child goes through a process of child diversion and successfully completes, then the matter is literally dismissed. So the child doesn't have a record. But you see that there's a section in particular where the judges interpret that taking responsibility means pleading guilty. And to our mind, that was never the intent of the act, Chuck added. Justice officials warned that requiring a guilty plea before diversion creates a serious legal and ethical problem, as it may expose children to convictions the program was created to prevent.